Please be seated. Mr. Gilbert.
Morning, Your Honor.
Good morning, sir.
Your Honor, may I approach?
Granted.
I'm here this morning with Christian Devontae Nix and 22 CF 1063. His charges are destroy evidence, flee and elude, possession of marijuana less than 20, operate a vehicle without a license. In negotiation with the state, he's agreed to plea as charged for the terms count 1, 11 months, 29 days in Okaloosa County Jail, credit for time served. And count 2, 11 months, 29 days, OCJ, concurrent with count 1. And count 3 and 4, time served. Court costs $548. And in discussing with Madam Clerk, there's 2 tickets. These go back to 22, and they've been sent to collections. We have requested if they can be merged into Smith, but I'm not sure that that's still possible. The clerk was going to check.
Madam Clerk, is that possible?
I did speak to my supervisor. She said it is possible. I'll notate it on the minute sheet. Do you have the case numbers for those tickets, Mr. Gilbert?
Yes, the figure is 22 TR 4939 and 22 TR 4940.
And any score sheet objections, Mr. Gilbert?
I didn't hear it.
Any score sheet objections?
No, Your Honor.
All right. Mr. Nix, if you'd raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down. You heard what Mr. Gilbert said on your behalf and you signed the written plea form?
Yes, sir.
How old are you?
26.
How much school do you have?
High school.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what you read in the form what Mr. Gilbert just announced to me?
Yes, sir.
Do you understand by this plea arrangement you're pleading no contest to the announced charges?
Yes, sir.
That tells me you believe the state could prove your guilt and you're not going to contest that.
Yes, sir.
By doing this, do you understand that you're waiving your right to a trial where the state would have to prove your guilt?
Yes, sir.
In this case, you'll be adjudicated guilty. You'll be sentenced to a year in the county jail, credit for all time served, concurrent on counts 1 and 2, and counts 3 and 4, time served, and then merge and dismiss the 2 traffic tickets. Yes.
I do see a third 2022 traffic ticket. That's 2022 TR 4941. Will that also need to be merged and dismissed?
They would agree to merge it.
All right. Now, does that change the amount of the costs?
I don't believe it does.
All right. So that would be together with all the fees and costs which were announced. And were they correct, Madam Clerk?
Yes, Your Honor. It would be 548.
All right. Now, how much time do you need to get that paid after you get out? A year going to be enough, you think?
Yes, sir.
Okay. Now, Mr. Gilbert answered all your questions about the plea and how it affects you.
Yes, sir.
And are you satisfied with how he's represented you?
Yes, sir.
The court find the plea to be freely and voluntarily entered into and will accept the plea with the adjudication. and that includes the merge and dismiss on the 3 announced traffic cases. Thank you.
Thank you, Your Honor. That's all I have.
Thank you.
Next we have Corey Barnes.
Mr. Weinstock?
Your Honor, I have 2 cases in front of you today. The first will be Corey Barnes, and this is case number 02CF2198.
Yes, sir.
The status as of today is I have contacted his previous counsel, Michael Ufferman, for his file. I've been informed by his secretary that he'll try to get it to me within a week. In addition, I've already spoken to the prosecutor, Ms. Herndon, about getting some other information from her, and her reply was that if it's not included in the Ufferman file, then she'll definitely get it to me. So as of this point right now, I need a continuance. How you doing?
All right. Ms. Herndon, anything from the state's point of view?
Your Honor, I did speak to Mr. Weinstock. I gave him my email address again and told him if he didn't have the items by 5 p.m. next Wednesday to let us know. The status with this, because of the age of the case, we have a fair bit that is still in paper form. And if he's able to receive it from Mr. Ufferman digitally, it makes searching for items much easier. But we're more than happy to paper copy. He let me know the 4 items, so we don't have any objection. We do have all those in our possession.
All right. My inclination is to set this off for a significant period of time to give you the chance to do everything you are. In other words, set a status. If you get everything and you feel like you're prepared, then you can reach out to the state and to the court team and get it set sooner. But what I don't want to do is just bring you back for a status and not be ready. Does that make sense? Is that something that makes sense to you?
I agree.
All right. Ms. Herndon?
Yes, Your Honor.
Although I'd love to see you here, it's no reason to bring you back just to tell me you're not ready yet. Is that okay? You understand where we're going, Mr. Barnes?
Yes, sir.
All right. In the meantime, because I think with that information coming in, you're going to need contact with Mr. Barnes. I'll renew my order asking that he remain here as long as that's okay with you, Mr. Barnes.
Yes, yeah.
Okay.
Yes, sir.
All right. All right, so what I'd like to do, let's set it in October. And the second date, Madam Clerk, what date is that?
October 22nd, Your Honor.
Nah.
The first day would be October 15th. And then after that would be November 12th.
Let's do it October 15th. And right now, we're going to call that a status because I just don't want to set it out too far and not see what's going on. And in the meantime, if it looks like you're going to be ready, then reach out. I don't think we'll be able to hear it in that time. If it looks like you're not going to be ready, also reach out to the state and let us know. And then we'll just go ahead and set your formal hearing after that. The goal here is I don't want to just forget about it. I want to have it on a date for status to be sure it's moving forward.
October 15 at 9 o'clock?
Yes, sir. And once again, that's for status only at this point in time.
I believe we're also calendared for September 24th for CMC.
Is that right, Madam Clerk?
I'm looking now. That is correct. There is a hearing set for 9/24 at 9 a.m.
All right, is it okay we cancel that and set it as status in 10:15?
Yes, Your Honor.
Once again, if you get in a position where you feel like you're ready, just reach out and we'll set it as soon as we possibly can.
I understand that. Thank
Okay.
you.
All right, thank you very much.
Thank you.
Oh, I'm sorry, one last procedural thing. Mr. Barnes had filed the pro se motion Regarding discovery, I believe we addressed that, but I think at this point in time, what you've done, I believe addresses all your requests for pro se your motion that you filed, Mr. Barnes. I believe Mr. Weinstock has now addressed all the items in that motion, correct?
Right, that's what we're doing right now.
Okay, all right, very good. So we'll indicate on the minute sheet that that's been resolved by Mr. Weinstock's appointment and request to prior counsel.
Yes, sir.
Okay, all right, very good. Thank you.
Next case I have is James Prelwitz.
Prelwitz.
Refused.
Say?
He refused transport.
The motion in front of the court is to take a deposition in this case, Your Honor. Like I pointed in my amended motion to take the deposition, I contend that the interview conducted, I believe in Oregon, was not conducted properly, and that the child made a number of accusations which can be proven to be false. I request the ability to take the deposition of this child.
I see that the state filed their response objecting, and this has been pending for some time, right?
Your Honor, I apologize for interrupting. I believe that this is one of the proceedings where the presence of the defendant is necessary?
I agree. Don't you, Mr. Weinstock?
No, I do not.
Okay, so you believe you have the authority to waive the defendant's presence on this, at this material stage of the proceedings regarding
I believe I do. I don't believe that this is a significant material fact that requires his attendance.
All right, well, so you're asserting that you're waiving the defendant's presence for the purpose of this hearing?
I am.
All right, well, we'll proceed.
Okay.
Tell me why it is necessary to avoid, and I use that word carefully, the generally accepted rule that such witnesses should not be subject to deposition.
Your Honor, when I listened to the recording of his meeting forensic interview, one of the things that stood out initially was the fact that the interviewer never confirmed that the child, I believe at 5 years old at this time, that the child had any idea of the difference between telling the truth and telling a lie. That was never affirmed during the interview at all. So we have no idea whether or not his testimony during this forensic interview was valid. There are a number of issues that the child made that we can show when I go in to take his deposition, that he basically made false assertions, and therefore his testimony is in question. I respectfully request the ability to talk to him.
Your Honor, the state has a different understanding of the interview. and submits that the interviewer, the forensic interviewer, started the interview by explaining to the child that, for example, if he didn't know the answer, he should say, I don't know the answer. And she provided examples, which the child responded and seemed to understand. Additionally, she went over the issue of whether or not something is true or is false by, for example, specifically mentioning this. She asked him how old he is. The child responded, I'm 7, which is true. It was true at the time of the interview. And then she states to the child, okay, if I say that you're 6 years old, and he responds, well, that is wrong, I'm not 6. And for the interviewer, I'm assuming that was enough to make sure that the child knew the difference between a truth and a lie. Additionally, there is no standard protocol or standard questions that an interviewer should ask the child, as long as the interviewer who's trained in that believes that continuing the interview will produce the truth from the child. And this is exactly what their interviewer has done. Additionally, I submit to the court that there have been other depositions taken in the case, for example, statements by the grandmother who can corroborate what the child says in the interview. She says that, for example, she observed the child and the defendant getting out of the shower, which is one of the facts that the child mentions during the interview.
I'm going to object. That has nothing to do with the interview that the child gave right now. What is important is the fact that the child never acknowledged that he knew the difference between a truth and a lie. Asking the child, are you 6 years old? He said, no, I'm 5. Does not differentiate the truth and a lie.
I'm going to let the state finish their argument. I mean, I don't presuppose where she was going with the assertion of corroborating evidence, but I'm going to let her finish her argument.
By mentioning that, I was touching upon the other two paragraphs written in the motion. The one, paragraph B, the complaining witness made a number of assertions that will be shown to be false. Well, that, for example, doesn't have to be accomplished by deposing the victim necessarily. It can be accomplished in other ways to impeach other witnesses and impeach, for example, even the forensic interviewer. He hasn't asked to depose the forensic interviewer to find out whether or not she believed the child and how she conducted the interview. Now, of course, one of the issues is the interview took place not in Florida, in Oregon. There hasn't been a request for deposition of the interviewer, the forensic interviewer in that case. And then the whole idea, I guess, motivation based on the defendant's motion to interview the child is the interview's trustiness is in question. Again, the child is right now, Your Honor, 10 years old. At the time was 7. There is a presumption that it shouldn't be deposed. The forensic interview presents many details from the child. Therefore, I don't believe this motion should be granted.
All right, and the core of your motion, although, and I'm not clear, I see the motion at docket identification number 178, which was filed on 5/4 of 26, I mean 6/4 of 26. Is that the motion we're referring to?
Your Honor, I filed my original motion to take depositions, and you denied it without prejudice for me to put more facts in the motion. So I subsequently filed the amended motion, filed on, I guess, June 24th, my amended motion to take depositions where I explained the reason why I wanted to do it.
June the 24th.
I believe,
Your Honor, it's July 24th.
Oh, it's
docket entry
July 24th.
184.
All right. All right. So the heart of is in paragraph 3, which is 3 bases, right?
correct.
And one is it wasn't conducted properly. 2 is the complaining witness made a number of assertions that will be shown to be false. And C, instead of 1, 2, 3, A, B, and C. C is the interviewee, the interview's trustworthiness is in question. So, and you've just argued the different basis here today, which is the belief that the way the interview was conducted didn't establish a sufficient foundation as to the, and I'm going to use the word child because all the case law says child, even though we know that it applies to anyone whose ability to know and understand the proceedings is in question. That could include someone who is cognitively impaired, not necessarily who is simply a child, because we know the case law applies to everyone, right? If there's
Yes,
a
sir.
question of their ability to know and understand the proceedings. But the case law often refers to child. So it seems prudent for the court to review the interview in camera and make a determination of those questions, because that's really the gravamen of your motion. The question of whether or not the assertions made will be shown to be false is for another time or date. You've kind of given a pinhole view of what might be there, but I'm not sure that that's necessarily I do not understand the prevailing case law that you should be able to confront the witness on assertions that are inconsistent with the defendant's views of the facts are sufficient to take the deposition of a child, restate that, are not sufficient in and of themselves to avoid the rule which precludes the taking of a deposition of a child under the circumstances presented. And so the court's only concern would be whether or not the person that conducted the interview laid a sufficient predicate for the child to know and understand the obligation to speak truthfully in the interview regarding the facts and circumstance which are the subject matter of this proceeding. If that's in question, then the court would then provide a remedy. If after review of that, and I don't think it matters really the jurisdiction in which it was made, so long as this court, and now if there's case law that says differently, Mr. Weinstock, you know me, I'm different. If you provide case law, I'll change my mind, but I don't believe that Florida law says there is any specific formulistic approach to the person conducting the interview making the decision of whether or not they believe the person being interviewed knows and understands the obligation to testify truthfully. It is up to the person conducting the interview, whether it be a judge or a layperson, to determine, based upon the questions they ask, if they believe the individual being interviewed understands the obligation to speak truthfully based upon the questions that were asked. And of course, as I've said before, I do this when I have a child testify, and I know that my work will be fly-specced by another authority, and I take that into consideration when I review these things. But I believe that's the law. Don't you agree?
I think so.
All right. So if you'll provide the interview to Ms. Natali in a form that I can see, of course, pass it by Mr. Weinstock first to be sure it is full and complete. I'll review that and I'll make a decision. I don't believe the other, assertions being shown to be false is a basis, unless you can show me case law that would allow you to avoid the rule that is in place in this case for a child victim.
So basically, if I may,
Yes,
you're going to reserve judgment based upon your review of the interview, correct?
correct. And I'm asking you to give me any case law that you have that says that the defendant's view of the evidence being different than the statements made by the alleged victim in the interview is sufficient in and of themselves to avoid the rule which precludes taking the victim's deposition. If you've got any case law about that.
Your Honor, sorry. For purposes of sharing the interview, would a digital copy suffice for the court, or you
Yeah,
prefer?
digital
a
copy's fine.
Digital copy, okay.
Yes.
If I can transfer it like that, I think it's a better way, otherwise I'll have a disk.
Just be certain it's not too large to pass through the matrix.
Yeah, yes, it's 35 minutes, so I'm not sure if that's too big or not.
Make sure I understand, the prosecution is going to send you a copy of the interview?
Correct.
Okay.
And I'm going to review that, and my review is going to be limited to the questions posed by the interviewer to the witness, laying the foundation of whether the witness knows and understands the obligation to speak truthfully in the interview.
I understand. Okay.
And then you have asked if you can provide any case law which would suggest that your belief that the defendant's contrary view of the facts is sufficient to override the rule which generally provides that an alleged victim under the circumstances should not be separately subjected to deposition.
Thank you. Would that be all, Judge?
Yes, anything else today?
No, sir. May be excused.
Yes, sir, you may. And if you would, please, I would like you, Mr. Weinstock, to follow up on with an order that says what we've done today, including that you orally waived the defendant's presence at this proceeding. Although Madam Clerk has it on the minutes, sometimes those minutes don't end up in the record on appeal or that 3850.
May I be excused?
Yes, sir. Thank you very much, Mr.
Thank
Weinstock.
you.
Thank you, Mr. Cotton. Sorry for that delay. I just
no,
wanted to
no.
finish my notes.
No, yes, sir. Your Honor, I have two cases on today's docket. The first one is going to be DeBaron Smith, case number 26CF0061, 21CF1470, and 2019 CF0431. I had an opportunity to gather some evidence, provide that to the state, and meet with the state attorney's office. We've reached an agreement to resolve this case, but one of those is that he be able to catch up all his back court costs and fines, which was being done today. His family has sent me a photo of certified funds being delivered to the clerk. That was one of the conditions we discussed that need to be completed before we resolve the case. So what I'd like to do, if you have another court date, a week out, or something of that nature, I think we're ready to resolve the case.
That's correct, Your Honor.
So you want to, we got a docket next Thursday?
I was unable to have everything done today.
No, I understand.
Yes,
I
sir.
understand. I mean.
Sure. I just want to make sure we
I mean,
fulfilled
it was
our
clear-
obligations.
It's clear from my notes last time that you were pushing to get it done today, and there was no subs, and you had hoped to.
Yes, sir.
So that's no problem.
Okay, thank
So
you.
all you have next week is pretrial detentions next Thursday. There is a case already set there for status, if you want to special set date for next week.
Judge, I would tell you,
Your Honor. I'm sorry, I can't because I'm in front of Judge Oberlisen next for a miscellaneous
Okay.
next Thursday.
I don't want to set it too far out, Judge, but part of the sentence does involve an incarcerative sentence to which he has not fulfilled the time requirement yet, so it's not a complete emergency. He would remain in custody at least for some period of time after the agreement was fulfilled. But if we have something in the next 2 weeks, 3 weeks, I think that would be fine. I don't know what the court's schedule or docket is.
Let's see, we don't have court again until the 14th of September. That's when pretrial conference starts. The next miscellaneous is not till 9/24. There is pretrial detentions, at least blocked out for the 3rd of September. I don't know if nothing is currently set at that time. We can do special stuff.
What
Yes.
was the pretrial detention statute?
Yes.
I'm sorry, we're prepared. Madam Clerk, what was that pretrial detention date that you said you had a hearing on? Next week?
Next week, the 27th at 12:30.
After speaking with Ms. Leone, since this is going to be a written plea and we've already agreed upon the terms, I think she might be comfortable that anybody could be here. So I will have a signed document provided to her before that date for her signature and review.
That's fine.
So whomever is here on that date, I believe she would be comfortable.
Change the
accepting.
plea on 8/27.
Yes, sir.
All right. Thank you, Mr. Smith.
Is that at 1:30?
No, it's 12:30.
12:30.
Yes.
Okay. All right, got it. I'll see you next week. All right. 12:30, 8/27. Your Honor, the next case I have is Knopf Thompson. Your Honor, I have a motion to withdraw that has been filed in this case. Mr. Thompson is currently incarcerated in St. Tammany Parish and has been incarcerated there. I'm pulling up the document that we've pulled. Currently in custody, has been in custody since May 24th. Obviously, I have the inability to have communication with him. And we have unfulfilled contractual obligations with my office, and I have filed a motion to withdraw. The original motion that I sent to him prior to filing as a courtesy copy was sent to him July 21st. I have had no response from that, and I have we sent him a e-filed copy on August 13th, Judge. I have had no response from that. I would request the court allow me to withdraw on this matter. Again, I don't presuppose that the lack of contact is voluntary in this situation, but without the ability to communicate and fulfill other contractual obligations, I'm unable to represent him in this matter.
State.
Judge, we don't have any position on the matter.
All right. Send me an order. Unless
I will,
you have one
Judge.
with you.
Sir?
Unless you have one with you.
No, I'll be happy to provide that to the court.
Only handle it once, right? So if you had it, I'd sign it right now.
I know, Judge, I appreciate it. That's all I have before the court.
All right, thank you now.
Thank you.
All right. Mr. Weaver.
Good morning, Your Honor.
Good morning, Mr. Weaver.
Jim Weaver on behalf of Tyler Shaw, case 26 CF 224.
Yes, sir.
Your Honor, this is a violation of probation. We were before the court last week and had a discussion regarding this case. The state attorney and I had an agreement as to the disposition, and the court had indicated that that would be acceptable in this case. We have a written plea form for the violation of probation. May I approach?
Granted.
Thank you. Mr. Shaw would like to enter an admission to the violation.
All right, and that's with adjudication of guilt, 90 days credit for time served, revoke and terminate, and any outstanding costs, which would be $100 cost of prosecution and any outstanding financials, correct?
Yes, sir.
And how much time do you need to get those things paid after your release? Is a year enough, you think?
Yeah, it is plenty of time, sir.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you put your hand down. You heard what Mr. Weaver said. You signed the written plea form.
Yes, sir.
You understand you're admitting the violation.
Yes, sir.
And that tells me, yes, I violated the way my officer says I did in that affidavit report.
Yes, sir.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove that violation?
Yes, sir.
And in this case, we've announced the terms. It's an adjudication of guilt if you weren't previously adjudicated guilty. 90 days in the county jail, credit for time served, revoke and terminate your probation, a year to pay outstanding costs, which include $100 cost of prosecution.
Yes, sir.
All right. Mr. Weaver answered all your questions about the plea and how it affects you.
Yes, sir.
Satisfied with how he's represented you.
Absolutely.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Thank you.
Thank you, Your Honor. Have a good day.
Good day. Mr. Powell? Yeah, hold on just a second. Madam Clerk has a question. Mr. Weaver, hold on just a second. Madam Clerk has a question.
Oh, not for Mr. Weaver's case.
Oh, I'm sorry.
With Knapp Thompson, he needs another court case set. There's nothing set after today. What would you like me to put this on? It's not for your case.
I apologize, Mr. Weaver. She had a question on prior case. Let's
Yes, sir.
put it on miscellaneous the second. No, the first one.
October 15th, Your Honor?
Yeah. Good morning, Mr. Powell. Good to have you back in our courtroom.
This is Cody Corporal Judge, 2018-227. We got a motion for early termination.
Your Honor, the state has spoken with the victim in this case, and there is no objection to an early termination of the probation in this case, and so the state would have no objection to granting the motion to early terminate.
All right, and, all right, very good. Do you, granted, and I get, supposing that probation will provide me appropriate order. Thank you very much. Good work getting this done and taken care of.
Yes, sir. Thank you.
All right, good day.
You don't want me to send an order to you, Judge, or you want to let the probation do it?
Ordinarily probation would, but if you want to double down, then that's fine too.
Okay. Good to see you, Judge.
Good to see you too.
Thank you.
All right, Ms. Yeski, I have Zachary Rogers on remotely for you. Isn't that your client, Ms. Yeski?
No, my client is in custody.
Oh. Zachary Rogers?
Yes, sir.
Are you represented by counsel?
No, sir. I'm represented by Mr. Jay Patel.
I'm sorry, by who?
Jay Patel?
If Your Honor, I can approach and explain the situation.
Okay. All right, Mr. Rogers, on the remote appearance, we've reached out to Mr. Patel's office to see when he'll be present, and as soon as he's present, we'll bring the other Mr. Rogers out from detention and do what's been requested. So I'm going to put you back in the waiting room, and as soon as Mr. Patel appears, then we'll, and that's not a criticism of him. I know that we've got 2 or 3 proceedings going on in the courthouse right now. So as soon as he gets here in this courtroom, then we'll bring you back in, okay?
Yeah, no, that's okay.
All right. All right, Mr. Henderson, you ready with your client? Do we have Mr., is it Stivers, right? Daniel Stivers, Mr. Henderson?
Yes, sir.
Mr. Weaver, did you have someone else?
No, sir.
Oh, okay.
No, sir.
Good morning, Mr. Henderson.
Good morning, Judge. It's been a while.
Yes, sir. Welcome back.
Thank you.
Come right up here. Yep, there it is.
Judge, this is Daniel Strivers, case number 26 CF 1426, and we're here on a motion to reduce bond, and I would like to call my client.
Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, sir, would you state your name for the record, please?
Daniel Stivers,
And you can put your hand down, sir, it's
Oh.
okay.
And how old are you, Mr. Stivers?
37,
And prior to being arrested, where did you live?
Pensacola, Florida.
And how long have you lived in this area?
About 25 years.
And sir, do you have any relatives in this area?
Yes, sir.
Who do you have?
My stepfather and mother live in Santa Rosa, Navarre. My sister lives in Shalimar, and my brother lives in Pensacola.
Prior to being arrested, were you working?
Yes, sir.
What type of work were you doing?
Internet support,
And how long have you been doing that type of work, sir?
13 years.
As set now, do you have the financial ability to make your bond?
As set now, no.
When you were working, sir, how much money were you making?
Just under 50,000 annual.
All right. Thank you. I don't have any further questions.
Any questions?
No, Your Honor, not from the state.
Okay.
Argument, Judge?
Yes, sir.
Judge, the way the bond's set at this time, it's $100,000 cash or professional for each count, totaling $400,000. My client is not capable or have the financial means to make that bond. So based on his circumstances and history and the nature of the crimes charged, I'd ask the court to reduce the bond. And what I would ask the court to do is set each bond $10,000 cash or professional.
All right, State?
Your Honor, the state objects to any change of the bond and the reduction of the bond. There is no change in circumstances from the first appearance setting of the bond. Nothing has happened since then. And Your Honor happened to be the judge of first appearance. I set the bond at $100,000 based on, obviously, the criteria that haven't even been examined by defense counsel, such as the nature and circumstances of the offense, the penalty, the possible penalty provided by the law in this case is up to 40 years. The weight of the evidence. The court is aware that the defendant actually made some statements corroborating what the investigation had produced. There were text messages. He acknowledged that he was the person sending the text messages, and he actually traveled from Escambia County, from Pensacola to Fort Walton Beach to have sex with a minor, and he even purchased condoms that were found in his car. In addition to that, about the danger that he poses to the community, obviously, we know that he was found to have a concealed firearm when he showed up, and he was charged with that count. The danger, obviously, we know is not to a victim in particular because it was an operation. However, the danger that he poses is to the children he was hunting during the crime. There is no evidence of indigency other than, or the fact that he cannot meet the bond other than his own testimony. We wouldn't know where the sources of funds will come from. The state also refers the court to Mehaffey v. Rutherford, 143 Southern 3rd, 432. In that, and it's a first DCA case from 2016. In that case, the defendant was facing the same 3 core charges: the use of computer to seduce, solicit, lure a child, traveling to meet a child after computer solicitation, and unlawful of a two-way communication device. In that case, the court has set the bond at $150,000 per count for a total of $750,000. The first DCA denied the habeas relief and left the bond in place, finding no abuse of discretion. And it also, and I'm quoting, simply because the defendant testifies that he cannot meet a given bond amount does not mean the bond is per se excessive or unreasonable. Based on that, Your Honor, the state is asking the court to deny the motion.
If I could respond, Judge.
You may, sir.
Let's start with the case law that the state cited. Each case is an individual case in and of itself. I know the state cited particulars in that case as to the type of charges, which are similar. However, we don't know what that individual's past criminal history was, what his ties to the community were, other things and factors that are considered in the bond. As far as the state making the argument that there has not been a change in circumstances, that's not required here, Judge, because this is not a pretrial detention matter. Once pretrial detention is set, then to be able to come back to address that, you have to show a change in circumstances. What we're coming back here is basically on the straight bond, that a bond is supposed to be reasonable, and there are things that the court can consider with the reasonableness, the nature of the charges, past criminal history, the ability of the individual to make the bond to be reasonable for their situation. And under this case, in the circumstances and past history, I feel that the bond, and my client feels that the bond is unreasonable at this time and asks the court to change it.
So the court's taking a moment here to review the first appearance paperwork, which includes the information collected by our pretrial services, which includes and you're suggesting the defendant has no prior criminal history?
No, Your Honor. What I'm saying is based on criminal history.
Okay.
It's my understanding that my client has, and from looking at the sheet, they were circled misdemeanors.
3 prior misdemeanors and 1 DUI is what it says. Also they've indicated that, that he was employed at the time and other circumstances, no adult felonies and no FTAs. And then the court considered the addendum of probable cause, which is fairly comprehensive. As those of us done this for a while, sometimes they're 2 or 3 sentences, right? And this one's 3 pages, which has significant details regarding the circumstances supporting the arrest in the case, and details significant circumstances regarding the situation which is the foundation of the probable cause for the defendant's arrest, and other factual circumstances which support the other charges. And as you know, I did the first appearance in this case, and part of the additional conditions of the bond conditions were that the defendant would be on pretrial services weekly, reporting by phone, monthly in person, have a GPS monitor attached before release, not possess or have any access to internet-capable devices, no unsupervised contact with minors, and not be out or about any place minors congregate. And at the time, the court asked the defendant regarding counsel, and it's not in any way appointed the public defender. I'm simply reciting what the paperwork said. And he subsequently retained you. After having reviewed those details and the circumstances presented, the court finds that the bond conditions under the circumstances presented, particularly since we have the firearm charge, the lure of the child, the travel to meet, and the use of the two-way communication device, the court finds that the bonds are reasonable in the circumstances presented and respectfully denies the motion for a modification.
Thank you for the time, Judge.
You're welcome, Judge. Good day. Good morning, Mr. Nopes.
Judge, bear with me just a second here.
Yes, sir.
So I've got Mr. Brewster. He's got several different case numbers, 24 CF 1650F, 1651F, and 1862F, and then he has 25 CF 2314, 2315, 1548, and 26 CF 0938. Judge, I've not received an update, I guess, on the, I guess he's in the jail, and I guess they're trying to restore his competency, that I've not received any update.
Yes, sir. We're waiting for him to come from the back, Mr. Nopes.
Okay. And if you need to pass me, I'm fine, Judge.
No, sir, we'll take care of you now. I think Mr. Brewster needs to be attended to.
I got you. Okay.
And Judge, while we're here, I just want to make sure that I'm not missing something. Did we ever get a evaluation that ruled him incompetent a second time? So I think that's what we were here for, is that there needed to be another evaluation that confirmed that so that we could then move forward.
Use the microphone, please.
I believe, Your Honor, that we needed to get that second evaluation completed so that we could then move forward. I think we were waiting on that, based on my understanding, Mr. Nopes.
Is that right?
I think you're correct. I was able to confirm which cases. I think there's 3 case numbers that the motion to have him evaluated needs to be filed in. It's on my desk to hopefully knock out when I get back to the office today or tomorrow.
No, because I think I saw one, Mr. Nopes, already, but I think because of the overlapping case numbers, they didn't all come in.
Right.
Judge,
I agree.
I'd like to apologize for my prior behaviors. I had a depraved mindset.
Yes, sir.
So, which is why I chose to act up sometimes in these court proceedings. However, and do so, am I labeled competent now?
Well, that's what we're talking about right now. Your lawyer's here remotely. Mr. Nopes is appearing because he had another court appearance, and I allowed him to appear remotely so we can move your case forward. You're undergoing another evaluation, and that's what we're discussing right now to try and move your case forward. That's the
So
goal.
I'm, right now, the status is competent, right?
Technically, your status is competent, but there are significant questions about that based upon your prior courtroom behavior.
Okay, well, I mean, since I have a rational decision to apologize to you, wouldn't that be obsolete?
No, sir. That wouldn't be my decision. That would be a professional who's qualified in making the determination of whether or not you are, and that's what Mr. Nopes is going to do to be
Okay,
sure
I
that
got one more
happens.
question, if you may.
Yeah.
If I'm filing my own motions and proceedings in the first DCA, I can give you a case number now.
Yes, sir, I've seen them.
Okay, that means I'm rash, I understand the concepts of going to trial. I know what you are, I know who these people are. There's no point in doing evaluation. I'm objecting to the evaluation is what I'm saying.
Yes, sir.
Because
And
I know what.
I understand that, however, the court has a lawful obligation to be certain, and the rules are the rules, and I'll apply the rules, and you must undergo the evaluation for a professional to make that decision, because I am not a professional in that field where I can make that decision. Okay?
Very
All
well.
right. All right, so Mr. Nopes, if you'll get me the orders, right now we're set for 9:14. If it doesn't look like they're going to be done, let me know so that there's no reason just to come back on 9:14 and say it's not done.
Yes, sir.
Okay?
Thank you,
All right.
Judge.
Thank you very much. Good day.
Thanks, Judge.
Yes. All right, Mr. Lupella.
I have one case on the docket, it's Julie Pace with a P. We had attempted to file a motion to continue, it just hadn't been signed on the order side of things yet. I think we were asking to move it to September. I think we'll be resolving the case on that next court date, though.
And that's my understanding, Your Honor. I believe, I'd spoken with Mr. Rare about this case. I believe that the hope is that we will actually have the PTI entered into and signed so that it wouldn't even be on the docket come that September day, Your Honor.
That's correct, Judge.
All right, and so what date is it that you want?
For control, I think it was the 17th of, no, 14th was the next court date.
9/14?
Yeah, I think that's prudent.
Just for status again?
Yes, there was a provision of the PTI agreement that we were changing to allow for some travel. The main issue in this particular case was restitution and payment of that restitution, so we were working with Mr. Rare and his client to facilitate their ability to travel as long as they get the restitution paid. So we're inserting that provision into the PTI, and then they're going to need to re-sign it and go get instructed by the probation for it to start.
All right, so 9/14 for status.
Thank you, Your Honor.
Anything else, Mr. Lupella?
That's all I have this
Okay.
morning. Good day. Thank you.
Your Honor, I have one in the courtroom, if I may address.
Okay.
Mr. Michael Williams.
Yes, sir.
Case number 26CF0241. Your Honor, Mr. Williams was deemed incompetent. I have a conditional release plan that's been signed by all parties. If I could approach the clerk to turn this in?
Yes.
Under the terms, he will get outpatient restoration.
Is he on the docket?
He's on my docket.
He was set on the docket, Your Honor.
It's NYE, correct?
I'm sorry?
Spelling of the last name?
Williams.
Oh, I thought you said Nye. I'm sorry, I apologize, Mr. Williams. All right?
Good to see you, sir.
Yes, sir. All right, may I have the report, please, Madam Clerk?
Yes, Your Honor.
And the state's reviewed and agrees?
Yes, Your Honor, we do.
Oh, he does need to date that.
Yes, he does. Yes.
Just need you to put today's date.
I don't, it's
8/20.
8/20.
Now, I believe that does require an order of acceptance and approval, correct? Placing him on the pretrial, on the conditional release, correct?
I'll get an order over here.
All right, all right,
May I approach?
granted. And, all right, and I think the way that works, since we don't do these frequently, the way that works is I believe the order places the defendant on the pretrial release plan, which is attached to the copy of the order. So I'm just going to let you submit the whole thing as one package so it doesn't get detached. But the court will accept the plan. You provide an appropriate order placing the defendant on the pretrial release with the appropriate language in there regarding violation and so on.
Yes, Your Honor.
All right?
I'll get that filed.
All right. Thank you very much, Mr. Williams.
Yes, sir, thank you. Thank you. Yes, ma'am, I do. Thanks.
Ms. Yeski.
Yes, good morning, Your Honor. I'd like to call Anthony Taylor, who's in the gallery, in 16 CF 1793. We have received an offer in this case which is related to possibly an inpatient treatment program. We're going to need a little bit more time to work that out, and Mr. Taylor just had a meeting with me. If we could set this for possibly the September 17th miscellaneous.
I don't think we have a 17th. I think that's been rescheduled.
Okay, is there?
I think 9/24, correct, Madam Clerk?
Yes, Your Honor.
All right. 9/24?
Need to update that in my calendar.
The change of plea on 9/24?
Without subpoenas status.
Okay.
Yep.
All right, very good.
Thank you.
Thank you now. Thank you, Mr. Taylor. Good day.
What's his first name? Your Honor, this is Mr. Jared Wagner. He doesn't have an attorney assigned. We represent him on his other case.
All right, so I'm showing I got 1646 and 25 TR 8394, and I'm showing Mr. McKinney.
So it does have us listed?
Jared Wagner?
Yes, Your Honor.
Yes.
Okay, on the docket that I have, the 25 TR 0839 says no attorney.
Let me just check my notes. I think when we were here before, we added the TR case to pull it in. And I think it may just be how it's printed, if that makes
Okay.
sense. So, Madam Clerk, let's just confirm. My understanding is the TR is traveling along and the PD is appointed.
I'm double checking, Your Honor.
With that said, Your Honor, we'd ask to set this for the 9/14 court date. We're trying to work something with the state.
All right. State?
No objection.
All right, very good. Stay in touch with your lawyer. You'll be back on the 14th. Thank you now.
Your Honor, I'm not seeing that the PD was appointed in the PR case.
PD is appointed in the TR case, and it's traveling with the CF case. Good morning, Mr. Patel.
Good morning, Judge.
And your client is on remotely, but I know that you may want to talk to Ms. Yeski before we do that, with her client.
With who, Judge?
With Ms. Yeski
Oh.
and her client before we do that.
Yes, if I could
And
just
that
have-
might be just a good chance for a comfort break, which I need at this point, so.
Very good.
I'll take a brief break, and I'm gonna, since we're doing that and you're gonna talk probably, I'm gonna turn this obnoxious noise on while I'm on the break.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take 1. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3,
and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays, 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, The sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just one block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa.
Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Please be seated. All right, we'll have Zachary Rogers, please.
Good morning, Judge. Jay Patel on behalf of Zachary Taylor Rogers, the gentleman on the Zoom, as opposed to the gentleman in the courtroom. We're moving for relief under 26 CF2, 26 CF5, 26 CF6, 26 MM2, 26 MM3. Has the court had the benefit of reviewing the defendant's amended motion to correct court records pursuant to Florida Statute 901.36?
Yes, I have.
Specifically, we're moving for relief under.
Does the state intend to traverse or demur the petition?
No, Your Honor. No, sir.
Specifically, we're moving to, for relief under 2C. I have asked for a significant amount of relief. I believe that the relief that I've requested in the motion, the court has jurisdiction to issue that relief, and I can provide a written order.
Ms. Yeske, on behalf of the other Zachary Rogers, what's your client's position?
We have no position. He's here on a violation of probation as a status state.
All right, Mr. Patel, if you'll provide the court an appropriate order, and I believe part of the relief you're seeking is a request to verify identity, right? Correct?
Well, I think the verification would be by stipulation of the state. Unless there's a specific paragraph that you're pointing to in my motion.
So I guess the confusion is we've confirmed this through the fingerprints of the person who is physically present in the courtroom as compared to other identifying factors of the person who is appearing remotely in the courtroom, who's your client.
There has not been an actual fingerprint comparison. As I understand it, when a warrant was issued for my client, probation learned that that was indeed the wrong person, and the warrant should have been issued to Zachary Troy Rogers, which is the individual present in the courtroom. The court, I don't know when the state was involved, but the state was certainly involved in those conversations, but the court issued an amended warrant. So it would be my belief that that part has been satisfied. I'm just wanting the paperwork to match up.
Because since the beginning, it's been Taylor.
Yes.
And it should have been Troy.
Yes.
And the social security number has been of your client and not of the person physically present.
Yes.
And you're satisfied that this order correcting the court records will be sufficient to resolve the issue for your client?
I don't know that I can ask for anything more that you can do.
All right.
I've thought about it, but
all right. Ms. Yeske, anything? All right. Provide me an appropriate order, and I think we need to go, of course, electronics. You'll need, I think it's prudent for every one of these cases to have the same order. So prepare the order with all the case numbers. But then file it as a proposed order in all the different cases. Is that, you see where I'm coming from?
I do.
And then address all of the identifying factors. I think that it might be prudent, I don't know if you've discussed this directly with FDLE or not, but it might be prudent that, that you close the loop with them to be certain that their records are squared away. And if there needs to be additional language in the order, then do so. And considering that we're going to have social security numbers and those kind of things, then you want to probably put an appropriate notice of confidential information in the title of the order so that the clerk is aware of that. Because FDLE may want a separate copy provided to them to go into the individual record of each case so that when they plug it into the electronic system, it covers your client on each one of those cases. That, you see where I'm coming from?
I do.
Because then they're going to push it upstream to the national system.
Yes.
Okay. Any issue, Ms. Yeski, what we're doing? Okay. All right. And so then that would result in this case style being changed to Zachary Troy Rogers.
That's correct.
All right. All right. All right.
That's all I have for this case.
All right. All right. Very good.
Thank you,
very
Judge.
much.
Would you like to call my next case or call Mr. Troy Rogers' case?
Well, since he's out here, we'll take care of him.
Your Honor, in Zachary Rogers' case, 26 CF2, 5, 6, as well as 26 MM2, 3. That's all I have. We are requesting a continuance without subpoenas. We're working toward a resolution still in this case.
The state has no objection.
All right. So when do we wish it to be continued to?
If there is an October miscellaneous,
Yes, there is 10, I think 15, correct?
Yes, Your Honor.
that would be great.
Okay, very good. Yes. And Mr. Rogers, remotely, you're free to go at this point in time, sir. We're completed with your procedure.
All right, I appreciate it, thanks.
Thank you.
Next, Judge Jay Patel on behalf of David Pearson, 24 CF 1310. Has the court had the opportunity to review the motion to modify probation?
Yes.
I don't know what the court's preference is here. We're asking for relief that's consistent with the term on pretrial services. He's just having an extremely difficult time trying to apply for a job. He's in Nebraska. If the court's not inclined to grant the relief as requested, then supplementally I'd ask for an order basically stating that after he completes an internet safety plan, that per Florida statute, he'd be eligible for, to access the internet. This whole situation's a little bit more challenging because he lives in Nebraska, and so they're just going by the paperwork.
All right, State?
Yes, Your Honor, the state objects, of course, to any modification of the sentence as imposed. It's a statutory requirement that he has no access to the internet until there is a practitioner, qualified practitioner has conducted a risk assessment and has approved the safety plan, and that safety plan has been implemented. That's what the statute requires. And the state would ask that that be completed and then be submitted to the court for further evaluation and possibly approval of the request to modify.
I'm not sure that it goes to the court. As I understand it, and maybe I'm wrong, but as I understand it, after the internet safety plan's completed, probation then makes the modification and sends the paperwork to the court.
That may be the case, but at least probation needs to be aware and approve it.
Yeah, I think what happens is I get the notification that they've completed and they notify the court that it's permitted.
Yeah.
Now, when they're in a sister state, I may have to sign an order for the benefit of the sister state because they may be concerned about compliance. I don't recall if there's a difference between the two. And I have no clue how they work up there, and if the issue is, if he wants to go to, I don't know, Jobs Plus and log on to the kiosk to look for a job, I don't have any issue with that. If that's his concern, I have no issue. And you want an order that says he can go to the job center, whether it's the local job center or if he wants to go to the employment office at school, he's welcome to do that and use the computers there under their supervision for the purposes of a job search. The problem, of course, would be is using his own device without direct supervision. I'm uncomfortable with until those other statutory conditions are met. Now, and once again, I don't know, don't mean to sound like a joke, but I don't know how they do things up there. And I don't want to put probation up there in a conundrum, but I have no problem with him doing that under the direct supervision of somebody in an office where that's what they do. And I don't believe the statute would preclude that either. Because if you think about it, if you're using your debit card, you're accessing the internet, right? Technically, right? So we don't say that that's a violation. So you see where I'm coming from. As long as you can craft something that says that, the court doesn't have a problem with that. The goal here is that it shouldn't be under such circumstances where it could lead to a violation and access which would lead to other circumstances.
Yes.
And once again, if you want to reach out to them up there, their supervision, and figure out how to do that, I have no problem. What I don't want to do, of course, and Mr. Patel, I'm very sensitive about laying a trap for any of the defendants. I don't want to do that. I want to be sure the details are correct, both from our state's point of view and the sister state's point of view.
I think what you said today I can put in paper, and I think that will help solve the problem.
Any issue with that state, with those conditions?
No, Your Honor. I guess, again, if probation is okay with that, I have no issues.
Right.
And I think the issue is it's not like Officer Howell can get in touch with Judge Stone's office. It's
correct.
A different state trying to read the paperwork from another state.
Right. And so clearly, as long as it's under direct supervision of the authority who is assisting, then I don't have a question about that.
Okay. Very good.
All right.
Finally, Jay Patel on behalf of Donovan Jermaine Taylor.
Well, hold on just a second. Yes, ma'am.
Just to confirm, that was the motion granted with the condition that he can use devices with direct supervision?
Correct.
Okay.
For the purposes of job search.
Oh, I did.
I have one more question about that, Judge, and I guess this is me thinking one more step. My assumption is that the court is okay. Like, let's say, for instance, he gets a job at Whataburger and he's using the cashier device that's the internet.
Ordinarily, those prohibitions do not include for work purposes, correct, State?
Yes, they don't.
So if it's under direct supervision at work, but all you have to do is look at some of these violation reports where folks figure out how to use the computer at work to violate their probation. So, you know, he needs to be aware that, you know, that.
No, I understood.
No.
Okay, Jay Patel on behalf of Donovan Jermaine Taylor, 24 CF 770. At this time, Mr. Taylor withdraws his previously entered plea of not guilty and tenders a plea of no contest to the amended information, which is 10 counts of unlawful use of a two-way communication device. The understanding is that on all 10 counts, it will be a withhold of adjudication, 5 years of probation on count 1, followed by 5 years of probation on counts 2 through 10 that are consecutive to count 1 but concurrent to each other. Essentially, Judge, the understanding is he is to do 10 years of probation. 667 in court costs. There are special conditions of probation, specifically no internet or use of internet-capable devices until the internet safety plan is complete per statute. However, the defendant may use the internet for work or school purposes while supervised until the safety plan is complete. There's a curfew from 10 p.m. to 6 a.m. that's adjustable by probation. He's to attend and complete the treatment recommended by the defendant's evaluation that was completed by Dr. McDonald. He is to have no unsupervised contact with any minors except for his sister, MT, date of birth 6/15/2009, and forfeit the seized device. May I approach?
Granted.
Additionally, Judge, I'd like to recognize his family and support system that's here today in the courtroom.
Raise your right hand for me, please. Do you swear, other one? Do you swear or affirm to testify truthfully in this matter under penalties of perjury? Okay, you can put your hand down.
Yes, Your Honor.
All right, you heard what Mr. Patel said on your behalf and you signed the written plea form.
Yes, sir.
How old
yes,
are
sir.
you?
I'm 19.
How much school do you have?
I just graduated this summer.
All right. You able to read and understand the plea form?
Yes, sir.
Did you
Yes,
do
Your
that before you signed it?
Yes, Your Honor.
And it's what you read the plea form, what Mr. Patel just announced to me.
Yes, Your Honor.
Do you understand by this plea arrangement that you're pleading no contest to the charges?
Yes, Your Honor.
And that tells me you believe the state has the evidence necessary to convince the jury of your guilt, and you're not going to contest that.
Yes, Your Honor.
Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
And in this case, your adjudication will be withheld on the charges. You'll be placed on the 10 years of probation, and Mr. Patel has announced that it's 2 separate terms, 1 5 and then followed by another 5. Do you understand?
Yes, sir.
With the conditions that were announced, talking about the internet devices, the curfew, and the evaluations that were discussed, and no unsupervised conduct with minors except for your sister, and forfeit the seized devices. Is that what you understood?
Yes, sir.
In addition to the other standard conditions of probation which were outlined generally in your plea arrangement.
Yes, sir.
And is this as charged?
Yes, Judge, it would be a downward departure, as charged in the amended information.
All right. That's what I thought. So there. Do you see the amended information, Madam Clerk?
Yes, Your Honor. It was filed August 17th.
Ah, okay. It just doesn't show. Okay, there it is. And so So, you know, Mr. Taylor, this is just about being sure that the documents match what we're doing. I don't like to do it over, because sometimes that means you have to come back and do it over. Mr. Patel has to do it over, so I'm just being sure everything's correct.
I understand.
All right, so, and that's to those 10 counts versus the prior counts of the possession, correct?
That's correct.
And because it's the amended information, it does not include the designations, correct?
That's correct.
Okay. Now, Mr. Patel answered all your questions about the plea and how it affects you. Has he answered all your questions?
Yes.
All right. Now, I'm just watching you. It looks like you do have a question, because I see from your face. You okay?
Yeah,
if you've got any, now's the time to ask. It's not a trick.
No,
if you're worried about anything, just ask him, and you can.
No, I'm good.
Okay.
I'm just paying attention.
Okay. And you satisfied with how you've been represented here?
Yes, sir. Yes, Your Honor.
And Mr. Patel has mentioned here that this is a downward departure. Do you understand what that means?
I'm pretty sure.
All right. So with the way the score sheet works is the state statute prescribes a number of points for each offense, and then there's a mathematical calculation which is prescribed by the statute, which ends up on the score sheet, and the score sheet shows that you have a score of 54.4 points, which means under ordinary circumstances you would be scoring for a prison sentence. And based upon the agreement with the state that this is a plea arrangement, you won't be receiving a prison sentence. Why that is important is a violation of probation would expose you to a presumptive prison sentence. And that's why Mr. Patel was saying that it's a downward departure. And I like to be certain people understand so that if you do have a violation, it's presumed, it's believed that your violation would result in you being exposed to a prison sentence. Do you understand what I'm saying?
Yes, sir.
Okay. All right. And with that, the court will find the plea is freely and voluntarily entered into and will accept the plea with a withhold under the circumstances.
Thank you, Judge.
Thank you, Mr. Patel. Thank you, Mr. Taylor. Good day.
Excuse me, sir, I have a question.
Yes.
I got two old actions. Will this be considered sex offender probation? Will you have to do all the terms and conditions that a normal sex offender would do?
My understanding is the standard probation, correct, with only the additional provisions is that no internet except for work or school until a safety plan is completed. So it would have to do the safety plan, correct?
Yes, Your Honor. That was what we were contemplating when we discussed this plea agreement, that it would be placed on sex offender probation, although it's not deemed a sex offender.
So it is sex offender?
No, it's not. It's standard probation with certain requirements that are also requirements of sex offender probation that are specifically listed in the plea agreement. It's a distinction with a huge difference.
Okay, so I think that's the reason probation is asking.
Right.
So this is probation with certain sex offender probation conditions, which is the safety plan and the curfew and the no contact.
Correct.
And attend and complete the treatment recommended by Dr. McDonald.
That's correct.
And so those would be typical conditions we would have in SOP, but it's not the full SOP conditions.
That's what we understand.
Does that answer your questions? Or?
Yes, sir.
Okay, and Mr. Taylor, the reason is important. Like I said, I like to do it once and not do it over. You report and then they've got questions, we're back in court. And your officer is your primary contact and will guide you through this process. So if they've got questions, then we can't complete it. So that's the reason I always authorize them to stand up in court and let me know if there's any questions, because I'd rather do it once than do it over. That's the reason for the questions, okay? And so we're good, you think?
And no GPS, right?
No GPS required.
Yes, sir.
Once again, so it's standard probation with the special conditions, no internet or internet-capable devices until the completion of the safety plan, but may use it for work or school purposes so long as supervised until the plan is complete. then the curfew, which is adjustable by probation for school or work, and then the treatment by the evaluation for Dr. McDonald, plus the no unsupervised contact with the exception of the sibling.
That's correct.
Okay, all right. Did you get a copy of this probation?
No, sir.
Okay,
I
you
can
want,
help
yeah, want to let them snap a pic of that, that way it'll speed things along for his reporting.
May I approach?
Granted. All right, good. All right. I think that covers all the details.
Thank you, Judge.
Anything
Maybe-
else from the state?
No, Your Honor.
Defense?
No, Judge, may I be excused?
Yes, sir. Thank you.
Judge.
Thank you now. Good day. And I have Destiny Clinton on Zoom without counsel.
Yeah, sure.
All right, good morning, you're Destiny Clinton, is that right?
You're muted right now, Ms. Clinton.
Yes, Your Honor.
All right.
Your Honor, we're here, this is a violation of probation to misdemeanors. The state is going to offer, I don't know if you'd be willing to accept it with it, her being over Zoom, but we're just going to offer admit the violation, credit for time served, revoke and terminate supervision, any outstanding collections just to a civil lien.
All right, were you able to hear that, Ms. Clinton?
Yes, Your Honor.
Is that something you're willing to do without the assistance of an attorney?
Yes, Your Honor.
All right. And has she been previously adjudicated?
This is a misdemeanor, Your Honor, but yeah, I believe she was.
Okay. All right, raise your right hand for me, Ms. Clinton. Oh, are you in the state of Florida?
No, I'm in Tennessee.
All right. You're about to get an oath in the state of Florida to testify truthfully. You willing to accept that oath in the state of Florida and be responsible for a violation of that oath in the state of Florida, which can include perjury or sanctions such as contempt?
Yes, Your Honor.
Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
All right, you put your hand down. You heard what the state's offering, which is an admit the violation. They'll allow the probation to be revoked and terminated. All your financial conditions would be sent to collections. Is that acceptable?
Yes, Your Honor.
All right, now, often when people agree to do that, I say, well, I'll give you a period of time to resolve your financial conditions, because when they go to collections, there can be other circumstances, for instance, driver's licenses and child support, and there's a whole bunch of other stuff. So if I give you 24 months to get all your payments made, do you think you can get everything taken care of in that period of time?
Yes, Your Honor.
Okay. All right, so I'll accept the admission. I'll allow the probation to be revoked and terminated. I'll waive any supervision costs and outstanding fees and costs. I'll provide 24 months to pay. And you can pay those to the clerk. And if you run out of time and you're making payments, all you need to do is ask, I'll give you more time. But if you're not making payments, don't ask for more time, okay? The goal here is to help you succeed. As long as you're making payments and progress towards resolving it, I'll help you, okay?
Yes, Your Honor.
Okay? All right, any questions?
No, sir.
Okay. All right, thank you now, good day.
Thank you, you too.
And for the record, this plea is being done without the written plea agreement.
Say again?
This
Yes.
plea-
Isaiah Richardson.
Your Honor, this is Isaiah Richardson before the court, 26 CF 1358.
Yes, ma'am.
We've come to an agreement in this case. I just need a moment to get Mr. Richardson's signature. In this case, it will be a withhold of adjudication, 36 months, standard probation, complete a substance abuse evaluation and any recommended treatment, maintain gainful employment or submit 3 applications per week, court costs, cost of defense, no alcohol, no controlled substances without prescription, random UAs, random breath tests, 50 hours of community service work with no buyout, must perform 8 hours per month until they are complete, and the state requests a reserve on restitution. And again, the adjudication will be withheld. I have the signed agreement as well as a score sheet. if we may.
State,
No objection. That's the agreement, Your Honor.
raise your right hand for me, please, sir. Do you swear affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, you can put your hand down. You heard what Ms. Yeski said on your behalf, and you signed the written plea form.
Yes, sir.
How old are you?
28.
How much school do you have?
Graduated.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what you read what Ms. Yeski just said?
Yes, sir.
Do you understand you're pleading no contest to these charges?
Yes, sir.
That tells me you think the state could prove you guilt to the jury and you're not going to contest that.
Yes, sir.
And by doing this, you understand you're waiving your right to that jury where the state would have to prove you guilty.
Yes, sir.
In this case, adjudication will be withheld. You're going to be on 3 years of probation with the evaluation recommended treatment. You got to get a job or submit applications. Also, my view of it is if you see that you can get some training or education which will lead to full-time employment or success for you, then I'll support you in that. So if you end up at, shows my age, I almost called it VOTEC, the school over here or up at the college. If you want to do that, then I'll support you. The goal here is to set you up for success in life, and that will qualify for your employment or seeking employment, okay? And just tell probation that, and they'll let me know, and I'll support you, okay? All right, and then you've got your court costs, which are, Madam Clerk?
$515, Your Honor.
$515 plus $150 state-provided legal assistance. And then you've got the community service hours, and it's been announced you can't buy those out. In other words, that's a material condition. You've got to actually do your community service hours. Sometimes we let folks buy those out, but they're saying that that's a condition. You've got to actually work those hours. Then you got to do them 8 hours a week until complete. Reserve on the restitution means later if you can't agree to an amount of the restitution, we may have a hearing where I'll decide what that is, okay?
Yes, sir.
Also, no substances, including alcohol, without a prescription. And you'll be subject to random testing about that, okay? And that is a material condition of this probation. If you violate that, you could be in violation of probation, all right?
Yes, sir.
All right. Ms. Yeski answered all your questions about the plea and how it affects you.
Yes, sir.
You're satisfied with how she's represented you.
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Now, probation is going to hand you some paperwork when you walk out regarding your reporting, so you be sure to follow their instructions, okay?
Yes, sir.
One second, Your Honor, I just need some signatures. Your Honor, we have Ms. Luandra Lucas, case number 25 CF 1905. We've reached an agreement with the state. In exchange for an admission of the violation, the state has agreed to an adjudication, 3 months, Okaloosa County Jail with credit for time served, $100 VOP fee, $150 cost of defense, and this would be a revoke in term. I have a signed plea form and score sheet if I may approach.
Granted. All right. Raise your right hand, please. You swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you can put your hand down. You heard what Mr. Cochran said on your behalf and signed the written plea form?
Yes, sir. Yes, sir.
All right. You understand you're admitting the violation?
Yes, sir.
That tells me, yep, I violated just the way that my officer says I did in that report.
Not exactly, but yes.
Okay, well, tell me what it is you're admitting then.
Well, I was really sick right before that. Went in to do that, and I was on all kinds of medication, and I was supposed to bring her all the different kinds of medication I was on, and then I didn't get a chance to do that.
Okay. So you disagree with what the report says, but you do agree you didn't follow her instructions to confirm what you believed happened.
Well, I was supposed to bring it in my next meeting, as far as I understood.
Okay. Given that situation, why are you doing this then if you don't believe you violated?
I just want to get it over with. And
Okay, how about this? After everything's considered, after you put all this thought into the process, you believe that this is a better outcome for you than going on to a hearing where the state would have to prove your violation?
I'm not sure.
You want to talk to your lawyer about it?
Yes, sir. It's under my best interest just to take the plea.
All right, so after everything's considered, even though you feel you didn't violate it, you think that this result is the best outcome for you instead of going ahead and going into a full-blown hearing where the state would have to prove your violation?
Yes, sir.
And with that, you understand you'll be adjudicated guilty if you weren't previously. Your probation is going to be revoked and terminated. Is that a big part of why you're doing this, is you won't be on probation anymore?
No, sir.
Okay, so that's not part of your consideration of why, huh?
Yes.
Yeah, okay, that's what I thought, right? Because you're not going to be on probation after you finish this 3 months, right? You're going to be out, all right? And so you'll have 3 months county jail, credit for time served. You'll have the additional fees and costs were stated. I'll give you 24 months to pay all your fees and costs after your release. Mr. Cochran answered all your questions about the plea and how it affects you.
Yes, sir.
You satisfied how he's represented you?
Yes, sir.
All right, the court will find the plea to be freely and voluntarily entered into and accept the plea, okay? Thank you.
Thank you.
I'd like to call a client in the gallery, Hansleen Smith. She's actually here for the 1:30 arraignment docket. If we could take her now.
Yes, give Madam Clerk a chance to get her minute sheet, okay?
Okay, and the case number is 26 CF 1364.
Granted.
At this time, we'll acknowledge receipt of the one count information, waive formal reading, and enter plea of not guilty.
Madam Clerk?
It's currently set on the November 9th docket, Your Honor.
All right, 11/9.
Thank you.
Stay in touch with your lawyer. Be back on the 9th of November unless you're given instructions earlier, okay?
Yes.
Does the state have an offer yet on this case?
It will be a probation offer, but we don't have all the terms. There's information as far as like restitution and that kind of thing from an alleged victim in the case.
Okay. And so if she gets that if Ms. Yeski gets that information for you sooner, she may relay that to you and you may come back to court sooner if you reach an agreement, okay? That's the reason it's important for her to have access to you to help you resolve the case. All right, thank you now. Good day.
Please have one moment, Your Honor.
Yes, sir.
Your Honor, we reached an agreement with the state, with Angela Miller, case number 26 CF 0677. In exchange for admission of the violation, the state has agreed to an adjudication, 4 months Okaloosa County Jail with any credit that she served, $100 BOP fee, and $150 cost of defense. If I may approach, I have the signed plea form and a score sheet.
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you put your hand down. You heard what Mr. Cochran said. You signed the written plea form.
Yes, sir.
Do you understand you're admitting the violation?
Yes, sir.
And that tells me, yes, Judge, I violated just the way the affidavit report from my officer says I did.
Yes, sir.
All right. Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
In this case, you'll be adjudicated guilty if not previously, and you'll be sentenced to 4 months in the county jail, credit for time served. With the fees and costs were announced, I'll give you 24 months to pay after your release. Is that what you understood?
Yes, sir.
Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, sir.
Satisfied with what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
This will be Daryl Wisdom. Your Honor, we have Mr. Daryl Wisdom, 2017 CF 3570. Your Honor, we're going to have to continue this. My client's trying to get placement at a facility in Walton County. We need time to facilitate that.
There's no objection, Your Honor.
That's basically the same place we were, correct?
Yes, Your Honor, we're still trying to get word from them.
All right, so when do we want to continue it?
The next VOP date. And if something happens between then, we can move it up.
It's going to be 9/24, right, Madam Clerk?
Yes, Your Honor.
9/24.
And if you get the placement, you know, I'll take that on any day that I'm here for pretrial or whatever, detentions, whatever, I'll take it.
Yes, Your Honor.
If you get it done. We'll just set it for status then.
Thank you.
So we just gotta get that facility. All right, so we'll come through. We'll come see you to talk about that. Yeah.
Next we have Smith.
I just have a moment for signatures. This is Michael Smith before the court, 25 CF 2299. We've come to an agreement in this case. Will be to admit to the violation be adjudicated guilty, reinstate the standard probation as well as all original requirements, and modify to include maintaining gainful employment or submitting 3 job applications per week, complete a mental health evaluation and any recommended treatment, and have 30 days to pay the restitution amount that is currently in arrears. $100 VOP fee and $150 cost of defense. May I approach with the signed agreement and score sheet?
Granted. Raise your right hand for me, please.
Yes,
Do you
sir.
swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, and you can put your hand down.
Yes,
You
sir.
heard what Ms. Yesky said, and you signed the written plea form.
Yes, sir.
All right, do you understand you're admitting the violation?
Yes, sir.
That tells me you agree that you violated the way your officer says you did.
Yes, sir.
You understand by doing this, you're waiving your right to a hearing where the state would have to prove that.
Yes, sir.
All right, you're going to be reinstated to your probation conditions with all your original conditions modified to include the employment and the mental health evaluation and recommended treatment, and that within 30 days you've got to pay the arrearages of the restitution plus the fees and costs that were announced.
Yes, sir.
All right, and as I tell everybody, if you think looking for a job or trying to get a job, you'd rather get training or education that leads to a better job and better success for you in life, then I'll support you with that. Talk to your probation officer and they'll explain that, okay?
Yes, sir.
Ms. Yesky answered all your questions about the plea and how it affects you,
Yes, sir.
and you're satisfied with how she's represented you.
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Mr. Fryer, you can go on.
This is Nigel Fryer, Your Honor.
I looked at it and I said, oh, we're not doing so bad. We're not doing so bad. Molly's already done all of her cases. Here.
So I need you.
All of yours.
Your Honor, we have Mr. Nigel Fryer, case number 20 CF 2443 and 21 CF 0192. Your Honor, we've reached an agreement with the state. In exchange for an admission to the violation of probation, the state has agreed to adjudication, term and revoke. It'll be 35 months Department of Corrections with credit for 18 months served in Georgia, plus all time served in Okaloosa County. $100 VOP fee and $150 cost of defense on both cases. So that'd be $300 VOP fee and cost of defense. If I may approach, Your Honor, I have the signed plea form. However, I do not have a score sheet today. We'll waive any objection to the score sheet and let the state file that.
Well, actually, it would be 100 on one case and 150 on the other, because he only gets charged the application once, right?
Yes, Your Honor.
So 250 state-provided legal assistance and 200 VOP. Okay. All right. Raise your right hand for me, please. You swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you put your hand down. You heard what Mr. Cochran said. You signed the written plea form.
Yes, sir.
You understand you're admitting the violation.
Yes, sir.
And that tells me you agree that you violated the way your officer says you did.
Yes, sir.
And by doing this, you understand you're waiving your right to a hearing where the state would have to prove the violation.
Yes, sir.
You'll be adjudicated guilty if you weren't previously. Your probation's going to be revoked and terminated. You're going to be sentenced to 35 months in the Department of Corrections, and that's concurrent both cases. Credit for all time served plus the 18 months served in Georgia. Mr. Cochran answered all your questions about the plea and how it affects you.
Yes, sir.
You're satisfied with how he's represented you.
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea.
Dennis Hooker?
May I have one moment, Your Honor?
Yes, sir.
We have Mr. Dennis Hunter on two cases, 26 CF 0707 and 26 CF 0858. Your Honor, we reached an agreement with the state in exchange for an admission. The state has agreed to an adjudication, 1129 months, Okaloosa County Jail. $100 cost of, $100 VOP fee, $150 cost of defense on 0707, and then on 0858 would be $100 VOP and $100 cost of defense. If I may approach, I have a signed plea form and a full sheet.
Granted.
Chris.
Is it a legitimate uncoerced plea bargain?
All right.
If I may approach, Your Honor.
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, you can put your hand down. You heard what Mr. Cochran said, and you signed the written plea form?
Yes, Your Honor.
Do you understand by this plea arrangement that you're pleading, you're admitting the violation?
Yes, Your Honor.
And that tells me that you agree with your officer on how you violated your probation.
Yes, Your Honor.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes, Your Honor.
You'll be adjudicated guilty if not previously. You'll be sentenced to a year in the county jail, 11 months, 29 days county jail, credit for all time served, concurrent. Is that going to be coterminous, state?
No, Your Honor, just concurrent.
Okay. And you'll have the fees and costs were announced. I'll give you 24 months to pay all your fees and costs after your release, okay?
Yes, Your Honor.
And Mr. Cochran answered all your questions about the plea and how it affects you?
Yes, Your Honor.
You satisfied with how he's represented you?
Yes, Your Honor.
The court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Yes, fine.
Just need one moment. This is Tracy Rosado before the court in 23 CF 457. Set as a status today. We would like to continue to the next miscellaneous date. We do have more documentation related to a group home, and we'll need to get those details sorted out.
No objection, Your Honor.
Our next is 9/24, but if you get a resolution sooner, you know that I'll take it anytime I'm here.
Thank you.
All right?
Your Honor, I have a client who's in another institution, Mr. Clarence Walton, 24 CF 1931. We've reached an agreement with the state. He's in Santa Rosa. I'm going to file an order to have him transported, and we'd like to set this for Thursday to enter a plea.
So, plea, you saying next Thursday?
Yes, Your Honor. Plea's already worked out. It's just a matter of getting him here.
All right, so that would be during our pretrial detentions next Thursday, because we don't actually have a docket on
Yes, Your Honor.
8/27. Is that okay with the state?
Yes, Your Honor. Someone will cover for me.
All right, plea on 8/27, get me an order on transport.
All right.
Brandon Zimms.
Your Honor, we have Mr. Brandon Zimps, 26 CF 0586. We're here for a status. Mr. Zimps was going to be conditional release. However, because the jail is not giving him medications, he has decompensated. We've tried Appalachia, but because he's not currently on medications, they wouldn't take him. So at this point, the only placement that is available is DCF placement.
All right, provide me an order.
We'll get an order, Your Honor.
Yeah, 10:15 for status.
This is Jeremy Grea before the court, 25 CF 1961. I just need a moment for signature. Again, Jeremy Ray before the court, 25 CF 1961. Come to a resolution in this case. It will be to admit the violation, be adjudicated guilty, 6 months in the Okaloosa County Jail, court costs, cost of defense. That also includes credit for all time served. May I approach with the signed agreement and score sheet?
Granted. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do, Your Honor.
All right, and you put your hand down. You heard what Ms. Yeski said, and you signed the written plea form.
Yes, sir.
You understand by this plea arrangement that you're admitting the violation.
I do.
And that says to me, Judge, I agree with how my officer says I violated my probation.
I do.
You understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
And in this case, you'll be adjudicated guilty, be sentenced to 6 months in the county jail, credit for time served with $100 cost of prosecution, $150 state-provided legal assistance. And I'll give you 24 months to get all your outstanding costs paid once you're released. Ms. Yeski answered all your questions about the plea and how it affects you.
Yes, yes.
Satisfied with how she's represented you.
Yes, Your Honor.
Court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Thank you. Thank you.
Can I go back to the road and terminate?
Road can terminate. Thank you very much, Madam Clerk.
Case the judge for me, please, ma'am.
Your Honor, this is Sarah Reacher before the court. 24 CF 1424. We're here on a status. She's been undergoing competency restoration services in the jail with forensic specialist Ms. Varela. We have received a forensic status update in the case. I believe it was e-filed today. I also have a copy. It appears that their competency restoration at the jail is still appropriate, and that is the recommendation to continue the services at this time.
State.
There's no objection to that.
All right, so set it for what? First pass in November?
I was thinking maybe we'd want to set it for an earlier, maybe a 1-month turnaround to keep it on the docket.
All right, 9/24.
Thank you. Just need 1 moment for signature. This is Chance Rubink before the court, 25 CF 1515. Come to a resolution in the case. It will be to admit to the violation, be adjudicated guilty, reinstate supervision, but modify to 12 months of community control, followed by drug offender probation for the remaining term of the supervision, as well as complete a substance abuse evaluation and any recommended treatment. $100 VOP fee, $150 cost of defense, as well as reinstate the original terms and conditions. I have the signed agreement as well as score sheet, if I may approach.
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
You put your hand down. You heard what Ms. Yeski said, and you signed the written plea form?
So yes, sir.
All right. Do you understand you're admitting the violation?
So yes, sir.
All right. And that tells me that you agree with your officer on how you violated your probation.
So yes, sir.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove that violation?
So yes, sir.
In this case, you'll be adjudicated guilty if you weren't previously. You will be reinstated to your probation with the following modifications. The next 12 months will be community control. The balance of your term would be to drug offender probation. You must complete a substance use evaluation and any recommended treatment. All the other terms and conditions are reimposed, and you'll have the additional fees and costs were announced. Is that what you understood?
So, yes, sir.
And Ms. Yeski answered all your questions about the plea and how it affects you?
So, yes, sir.
And are you satisfied with how she's represented you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you now.
Thank you, sir.
Take Stevens.
Just need one moment.
Yes, ma'am.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just one block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take 1. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working.
Whoa! Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday
Thank you for
10
that
to 3,
extra time.
and it's both our
Again, this is
Crestview,
David
Fort Walton
Stevens
Beach,
before the
and Eglin Air
court
Force Base locations.
in
So
24
you have
CF
things to do,
2740, 24 CF 2743, 24 CF 2744, 24 CF 2778. We've come to a resolution. It will be to admit to the violation, be adjudicated guilty, reinstate drug offender probation, as well as all the original requirements, and modify to include Jada House. There will also be a $100 VOP fee and cost of defense. And Mr. Stevens is aware that he is to report to Jada House tomorrow after being released from the jail. May I approach with the agreement, and the score sheet will be with you momentarily.
Granted. All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
All right, and you put your hand down. You heard what Ms. Yeski said, and you signed the written plea form?
Yes, sir.
Do you understand you're admitting the violation?
Yes, I do.
And it says to me, yep, I agree that I violated the way my officer says I did.
Yes, Your Honor.
And do you understand by doing this, you're waiving your right to a hearing where the state would have to prove your violation?
Yes.
And you'll be reinstated, you were previously adjudicated guilty, you'll be reinstated to drug offender probation with all your original conditions with the modification that you have to enter into and successfully complete JDA.
Yes, sir.
And one of the conditions is you gotta be there by tomorrow morning,
Tomorrow morning, yes, sir.
right? If you get out of there soon enough to be there today, you gotta be there today.
Okay.
But tomorrow morning at the very latest. The reason I'm saying that is a material condition of your plea.
Yes,
They're
sir.
gonna check on you. Right?
Yes.
No, they're gonna check on you.
Yes, sir.
And if you're not there, they're gonna tell me. And why is that important? Because you're a violent felony offender of special concern, and they're instantly gonna report that you are not there.
Yes, I understand, Your Honor.
And you're gonna go back to jail, and you're gonna be held without bond, because those are the rules. So, important. If anything happens, for whatever reason, I mean, it doesn't matter. You need to call your probation officer, tell them what's going on and why. As long as they're in the loop and understand what's happening, then, you see where I'm coming from.
Yes, sir.
Okay, all right. With that, Ms. Yeski answered all your questions about the plea and how it affects you.
Yes.
Satisfied with what she's done for you.
Yes, sir.
All right. I'll accept the plea as freely and voluntarily entered into. Thank you.
Thank you.
This is Samuel Strength before the court, 24 CF 2555. He's here on, as a status on the violation of probation. We have, everyone is in agreement with drug court, and he's ready for a plea next Wednesday into drug court.
Thank y'all.
So if we do need to put this as one more status, but this should drop off the docket.
All right, so he's supposed to take the plea on the 26th?
That's next Wednesday, then yes.
And so let's arbitrarily choose status for 9/14. I know that's a busy day, but we don't have one until 9/24, so let's just say status on 9/14 to be sure everything's squared away.
That works.
Okay? All right, very good.
Thank you, guys.
Thank you. Good day, sir.
I believe I have a few others on the docket. Sean Perkins, 26 CF 271. From our understanding, he's still held in the other institution. I believe that was Virginia. This was set as a status. I'd have no objection to setting it as for another status, maybe in November or October.
10/15, good?
That works.
State?
Good with that, good with the state, Your Honor.
And then we have Joe Petite, that's on the docket, 24 CF 2912. He pled into drug court August 4th. So that should have dropped off. We don't need a status.
All right, the state agrees.
Yes, Your Honor.
All right.
Then I also have George Sharp on the docket, 25 CF 1006, 25 CF 1023, 25 CF 1025, 25 CF 1217. Mr. Sharp was transported to Appalachia for competency restoration on August 18th, 2026. We may need to set that one also as a status.
First week in December, I would say.
December would work, yes.
All right, Madam Clerk.
That would be December 17th, Your Honor.
All right, 12/17 for status.
I believe that's everyone.
Jeremy Ray.
That case pled today, admitted the
Alrighty.
BOP.
We already pled that, that's right.
Ms. Seski, just so I have it correct on my minute sheet, when was the defendant transported?
Mr. Sharp,
Yes, ma'am.
August 18th, 2026.
Angela Miller.
Solver on.
Okay. All right, that's done for this morning, huh? Is that right?
Yes, Your Honor.
All right, very good. Well, we got us 10 minutes then.
All right.
All right, good. See you then.
Your Honor, may I approach one second?
Yes, ma'am.
This is the disc for the hearing on the motion to depose the child with Mr. Weisstock. Now, he has not reviewed this because he was gone by the time I obtained it, but I spoke with him on the phone. I told him what is on that video, and he said, yeah, please, that I haven't reviewed.
All right, very good.
Thank you.
Thank you.